And recording is on. Good afternoon, everyone. My name is Liz Beneski, and I'm the Executive Director of AmSham Abu Dhabi. It's my pleasure to have AmSham Abu Dhabi's Legal Affairs Committee, in collaboration with Accenture, Afridia and Al and Crowell and Mooring, present today's subject, U.S. anti-boycott law in the U.A.E., why it still matters. Just do the right thing and keep yourself on mute. Put those questions in the chat box and do come on camera. We like to see everyone. The webinar is being recorded and will be shared after the webinar along with a brief post-event survey. We'd also like to give a warm welcome to our fellow AmSham members in Bahrain, Dubai, Oman, and Qatar today. Right now, it is my pleasure to introduce one of the founding members of AmSham, a former board director and a friend of mine, the Honorable John Mcgowan with JPM Legal Advisors Global. John will be moderating the event and the floor is yours. John, take it away.
Thank you, Liz. Good afternoon, everybody. As Liz mentioned, I'm John Mcgowan. I am, in addition to being a director of JPM Legal Advisors, I'm also of counsel to Global Advocacy and Legal Counsel, a law firm in the U.A.E. I'm very excited and delighted to be able to moderate this esteemed panel on such an important topic. The Abraham Accords were signed just a few months ago, mid-September. And I'm sure many in our audience watched the proceedings on the South Lawn of the White House. And for those of us who have been in the U.A.E. a while, it was a seminal event. It was fantastic and certainly something we all thought would happen one day, but we were never quite sure when. And so anyway, of course, with that comes a bunch of business issues and business endeavors, and everybody wants to start rocking and rolling and doing business in Israel, and the Israelis doing business here and in the Gulf, and all that's great. And by the way, it is happening. AmSham Abu Dhabi and the other AmShams are in the midst of all of that, and we're very excited. But there's still some legal issues. As the Legal Affairs Committee, it's our job to make sure we stay grounded on a lot of the important legal issues. So our panel today it can't get any better than this, frankly. We have DJ Wolf, a partner and attorney at Crowell & Mooring out of the London and Washington offices. DJ is also a director at C&M International, which is Crowell's firm trade policy affiliate. DJ does compliance with U.S. sanctions, export controls, and anti-boycott regimes, and anti-money laundering. So we're looking forward to what he has to say about the rules at Treasury and Commerce, and the existing rules, and where it fits in with the Abraham Accords. We also have on our panel Jim Stearns, Director of Legal Services, Trade Compliance, Asia Pacific region for Accenture. Jim is Accenture's Director of Legal Services for Trade Compliance. He was previously at Intelsat, which is one of the largest satellite operators, if not the largest. And he previously was in private practice in Washington, D.C. for 20 years. So we're eager to see what Jim has to say about the nuts and bolts of how clients are reacting. What are the issues they face when it comes to boycott issues and what's going to be happening now that we have the Abraham Accords, and presumably U.A.E is no longer, or will soon no longer be officially a boycotting country. And then we also have on the panel our own Charles Laubach, the chairman of the Legal Affairs Committee. And Charles is one of the most experienced lawyers in the U.A.E. He's a lawyer's lawyer. So whenever lawyers have questions, including myself, we often go to Charles. He knows these issues as well, the sanctions and the export controls. So I'm anxious to hear his perspective. I know he's put together some clauses that we're going to look at. And and Charles is also on our board of directors. He's the corporate board secretary. So without further ado, let's dive in. DJ, what do you have for us?
Great. Thank you, John. Thank you, Liz. Thank you, everybody. Good morning, good afternoon to everybody. Pleasure to see everybody. It is a little early here on the East Coast, so I hope you excuse my coffee that I will drink heavily on the call. John, I don't know if you have a copy of my slides or if it's easier for me to present them. It's probably easier if
I think Sharad will do that.
Give me a second.
Perfect. Thanks, Sharad. So I get the privilege of trying to introduce an area of law that has been described to me as the arcane corner of the arcane area of export controls, and I get to do it in 4 minutes. So I hope everybody will excuse me. This is not going to be a boycott 101, but we're of course happy, and I'm sure Charles and Jim and John as well, to answer questions. I just want to level set a little bit at the top of a couple of minutes about what we're talking about, to contextualize how the Abraham Accords changed or didn't change some of the obligations under those rules. So at a high level, the US maintains 2 sets of anti-boycott regulations. They are administered by the Commerce Department and the Treasury Department, and they're very similar, but for those of us who've worked in the area, the importances are in the differences. So the prohibitions, the reporting obligations under both sets of rules vary slightly. It is important to note the anti-boycott regulations are not specifically targeting the Arab League boycott of Israel. They don't say that anywhere in the regulations, but in practice, that's what they were drafted to combat. They also have not been updated since the late 1970s. And so as we talk later through the course of these slides, and particularly as we get into the discussion, and trying to overlay a 1970s set of regulations onto a 2020 global commerce world, let alone the impact of the Abraham Accords, that's where some of the confusion is going to come in. Next slide. The easiest way to sort of summarize how to think about a boycott issue is kind of to pose 4 questions to yourself. First, do I even need to care? Like, is the thing I'm looking at actually subject to US jurisdiction? Problem is here, under both Commerce and Treasury, the rules change. Commerce, the rules require you to be a US person, but also to have it be within US commerce, which generally speaking will require a good or service to be coming from or to the United States. So often for business in Abu Dhabi, that may not be true. You often may have transactions that would fall outside the scope of commerce jurisdiction, but you may have others that will. The hook from almost everybody on the call is going to be the Treasury jurisdiction. Treasury Department's boycott rules jurisdiction attaches to US taxpayers and their global affiliates. So it brings in the whole corporate group. And given the context of everyone on the call, as an AmCham, almost everybody who is paying US taxes will fall within scope of the sort of jurisdiction of these rules. So question 1, often the answer is going to be yes, it's subject, so I need to care. Okay, so what are the sets of rules? Commerce and Treasury both contain a complicated overlay of prohibitions that, generally speaking, prohibit compliance with a boycott. They also prohibit agreements to comply with the boycott. They prohibit even furnishing of information related to compliance with the boycott.
We have shawarma. Is it ready?
Yes, it is.
Chicken?
just encourage everybody to make sure you're on mute if you're not actively posing a question. And Charles will later go through a few clauses that sort of lay out some of the odd ways that this ends up coming up. But so agreements to comply, actual compliance, even furnishing of information related to compliance. If the answer is, and here we'll see as we talk about later, it doesn't actually have to say the words Israel or boycott. Often both sets of agencies will interpret other language as being implicitly boycott related. And that's some of the nuance. And that's one of the areas where the Abraham Accords will have an impact, as we'll talk about probably in 10 minutes. So if the answer is, yep, it's caught, there is something that is sort of boycott related that is either prohibited by commerce or penalized by Treasury, then you sort of think through, is there an exception that applies? And here there's a whole sort of litany of rules that, it looks like on its face, it says you can't ship this product directly from Israel. Well, that certainly seems boycott related. It seems like it's probably prohibited, except there's actually an exception that covers that particular statement. But if you change that statement, even one word of that statement, it can be prohibited. And so this is often where companies have a policy in place that if there's anything even close to boycott related, escalate it up to somebody like the four of us on the call to help dig through the nuance of, is this within the exception, so we're okay? Is it outside the exception, so we're not? And then finally, unrelated to the prohibitions, both commerce and Treasury contain a reporting obligation. So you have it, some transactions, most transactions that are prohibited or penalized are also reportable, but you can have situations in which the actual clause is permissible, but still reportable. Commerce Department, you're required to report 4 times a year or every quarter. For companies in the US, that's 1 month after the quarter. For non-US affiliates of US companies, it's 2 months after the quarter. For Treasury, that report is part of a company's annual tax filings. And so you will end up doing that annually on whatever your fiscal year is. But as part of that, you report any requests you have received. And so this is as simple as if in an RFP to which you intend to respond, it says something like, do you comply with the boycott of Israel? Or will you agree to comply with the laws of boycotting country? That is a request to comply with a boycott that needs to be included often in your usually Treasury reports and sometimes commerce reports. So backing out of the weeds slightly, the thing to remember, it's a complicated area. Activity in Abu Dhabi, particularly for the companies on the call, is likely subject to jurisdiction. And you always have to think about, is it prohibited by commerce? Is it penalized by Treasury? Is it reportable to commerce? Is it reportable to Treasury?
Quick question, Jay.
Yep.
Is there are the forms online for the reporting? Can you get those online?
Absolutely. They're on both the Commerce Department's website. If you look up Office of Anti-Boycott Compliance and Reporting, their forms are there. There's a form for both a individual report and multiple reports. And then the Treasury report, your tax team often has it, but it's also available online to a bunch of complicated boxes to fill out, probably half of which those of us lawyers on the phone can fill out, and the other half you need your tax and your accountants to fill out the tax components. Okay. So with that, John, I'm back to you.
Yeah, great. Thank you, TJ. Good stuff. Mr. Jim Stearns from Accenture. What's your take on this from dealing with clients in the region from Accenture's standpoint? And also in light of the issues that DJ has laid out.
You're still on mute, Jim.
Apologies, I was having a problem getting off mute. The computer doesn't like it, so can everybody hear me okay?
Yes, sir.
Excellent, thank you very much. First of all, let me thank the Chamber for having us and for all of you being on the phone to listen to us. particular thanks to DJ, who is my outside counsel on anti-boycott questions and who helps us deal with the very difficult issues. And also to our legal team, not on the call, but many of you, I'm sure, know Francesca Gori, who heads the Middle East legal team. And Francesca is tremendous at making sure there is compliance, making sure we get the information that we need to do the job. And I pay tribute to her because really, although I'm the face of this discussion, she does a lot of the legwork, as does her team. Now, as a DJ has set the standard very well, I think, for what we're looking at. Just so you know about a censure, we report under the Treasury Department regulations for the reasons that DJ mentioned. We work very closely in trade compliance, which is the legal arm of a censure that would deal with boycott issues and is the organizational function in which I reside. Our big concerns are, and this is where Francesca helps us immensely, is to make sure that we see all the contracts coming in from the Middle East so we can make a determination whether there is a boycott request or not, and if there is a request that there is no improper compliance with that request. Our feeling is censure, and we may comment on this later on in the question and answers, but our feeling as censure is you need to show the United States government, should there be a violation, that you had a policy, that you had policies and procedures in place to catch the potential issues, and that is important. So we have all Middle East contracts and RFPs reviewed by trade compliance. Now, the practical problem that we faced before the accords was that 95% of our contracts have language in there saying something to the effect of you will comply with the laws of the country in which the entity resided that we were contracting with. So if we were in the U.A.E., clients would come back to us and say, you will comply with the laws of the U.A.E. Let's face it, that's not an unreasonable position in most cases, but it is not something we can do without some caveats to it. So we, over the course of many years, have worked out language that in essence says we will agree to comply with the laws of, and I'm just going to use the U.A.E. here, but it could be in any Middle East country recognizing the boycott. We will agree to comply with the laws of Abu Dhabi, except to the extent they violate regulations promulgated by the U.S. Department of Commerce or the U.S. Department of Treasury. We've worked very hard over the years to make sure that we basically have no language in there that discusses the boycott directly when we put our language out to our clients. We found that causes a major problem with our clients, so we have not done it. Occasionally we'll get a question back saying, what does that mean? And then we'll explain it. That has worked pretty well in the almost 8 years that I've been here at Accenture. Now, with the Abraham Accords, the question becomes, and I think many of you may feel no problem, and indeed the seminar is designed to discuss the issue. No problem at all. What's the issue now? The boycott law has been repealed. And from the point of view of U.S. business, at least from the point of view of Accenture, there still does remain a problem, and the core issue to us is, does the language which drops the necessity to comply with U.S. law, or scratch that, pardon me, do the Abraham Accords, which drop the boycott law, mean that we have no responsibility for compliance? And the answer to that is clearly no in a censor's view. We can accept now, and since the Abraham Accords have come into effect in September of this year, we've had two boycott requests from the United States that would have been requests under the old law. And now we do not deem them to be either requests or things that we cannot comply with because there is no longer a boycott law in effect. So we will not report those requests, and we will agree to comply with U.A.E. laws because there's no longer a boycott law in effect. However, and this is a big however for us, we are unclear as to whether the statements would be made that the Treasury Department would take issue with otherwise in the contract. So for a period of time, and DJ and I and Francesca are discussing this, we're still treating contracts and RFPs from clients in the U.A.E. as being subject to the boycott, just till we can ascertain whether in fact they still will exist in contracts. Because were they to exist in the contract, in essence, we would have to make their reporting to the Treasury Department, and we'd have to make sure that we didn't agree to comply. So it's a little bit of the good news is the Accords came and repealed the boycott law, or repealed compliance with the boycott law. And the bad news is we're not sure what's going to come across in the future. So that's,
Yeah.
Go ahead.
What kind of reaction did you get, or over the years? I'm sure you refined the language to put the caveat in there. When the provision says, the contractors should abide by the rules and practices of the U.A.E, and then your team would add language in there to say, with the exception of, and so, that wording, I'm sure, was refined over the years. What kind of reaction have you received from Treasury and Commerce? I mean, obviously it was accepted. How did, in other words, it was accepted on both sides, right? It was accepted by the U.A.E party, right? They would have had to agree to that contractual amendment, correct? And then from the government side, that clearly was okay from the U.S. government.
Yes, almost well before. I've been here almost 8 years, and I think this it has been refined over the years, but and checked on over the years, rechecked with the United States government. When we file our annual report every year as a taxpayer, we bring in the language, because you have to report the request and then you have to report what you did with it. So the Treasury Department sees our language every year, and they have accepted it. We have not, because we're not subject to Commerce jurisdiction. We did not ask the Commerce Department to review that. I will say, from the U.A.E. perspective, the perspective of clients in the U.A.E., as I mentioned before, sometimes they would say to us, "What does that mean? I'm not going to. What regulation are you talking about?" And then we'd explain the regulation, and they'd say, "Okay." There was a desire, at least with dealing with us, and well over 95% of the cases, I would say, that this did not become an issue. Occasionally, and not so much in the U.A.E. as in some other Middle Eastern countries, occasionally they'd say, "We're not going to agree to that," and then we'd have a protracted discussion, and the position of the client would be, "We have to comply with that boycott law, and you're going to have to comply with it." And then we would ordinarily get to their outside counsel, and we would negotiate with the overwhelming number of cases, the language staying in, and in other cases we make minor tweaks, which DJ would help us with.
Sure. Wonderful. I know Charles has some things to say about clauses and as they still exist in the U.A.E, and also we'll have a perspective on 20 plus years ago when the secondary and tertiary boycotts were supposed to have been shelved, but were not. So Charles, can you pick up where Jim has left off and give us some perspective and also your thoughts on where we are now?
Yeah, certainly. I'll try and keep my remarks relatively brief. Does it sound okay?
Yes.
Okay. The U.A.E began observing the Arab League boycott of Israel in 1972. And John and I, no doubt, remember when it was full-throated and the U.A.E fully boycotted Israel, and it required all these certificates and undertakings and agreements from companies doing business in the U.A.E also to agree to comply with the boycott, which created all kinds of problems here. There were documents in the licensing process, trademark registration process, and of course, contracting language that were just part of the landscape. And it was a constant challenge to make sure that permissible language could be negotiated with your counterparties in the U.A.E. And there were charges, there were prosecutions, there were fines, there were penalties imposed. And many companies doing business in the U.A.E, inadvertently perhaps, or with their eyes, willfully closed, committed violations and got caught. Now, in the early 90s, all 6 countries in the Gulf, Kuwait, Saudi Arabia, Bahrain, Qatar, U.A.E, and Oman, agreed to end the secondary and tertiary boycott of Israel. The primary boycott, that is Israel goods, persons, shipments, that stayed in place, but the other stuff, the maintenance of a blacklist of people who do business with Israel, like Coca-Cola, that went out the window. The tertiary boycott, don't do business with companies on the blacklist, that went out the window. And so the U.A.E and its neighbors began, treating companies, American companies that also trade with Israel, normally. And the temperature came down quite a bit. It became a lot easier to do business without having to, worry about 2 different incompatible legal systems. But what did not change is the forms. And this is what still bothers me today. All the major contractors in Abu Dhabi and Dubai, federal Abu Dhabi, all around, kept their old pre-1994 language that had all these clauses about no components from Israel, you must comply with U.A.E law, and all the rest of that. And my hunch is now, and again, prosecutions are still going on. As of last year, there are prosecutions for violations of the anti-boycott law by companies doing business in Abu Dhabi. So it's not a dead issue anymore. And the Abraham Accords have changed the boycott statute from 1972 has been repealed, but I don't think the business environment out there is totally clean of forms. And it's the issue now is, okay, the U.A.E no longer supports the boycott of Israel, but what if a big government contractor makes you agree in your form that you will observe the boycott of Israel? Then what happens?
Yeah.
That's the problem. And let me turn to some language. Sherrod, can you get my slides up? And I'm gonna go through this fairly quickly, but this is the kind of stuff you still see. Example 1, DJ mentioned earlier, the primary boycott, that's the primary boycott. So what is it? Can you agree to that language? Actually, you can. Is it reportable? Yes, it's reportable, but it's not prohibited. Likewise, the second one. Actually, the second one isn't even reportable. You can provide a certificate of origin that the goods are entirely of U.S. origin. The third one's a problem because it certifies there are no materials of Israel origin because there you're talking about the relations of your suppliers. It's been deemed to be a furnishing information violation. They look the same, but example 3 is not only prohibited, but also if you get it in proposed contract language, you must report it. Can I go to the next set of examples? Here are some more shipment rules. Again, these are still in circulation today. But the first one, example 4, this it requires a contractor to acknowledge that the customs laws and regulations of the U.A.E. will apply to shipment of goods and components. And it says these specifically address or prohibit goods and components that originate in Israel, that are manufactured in Israel, or that are produced or furnished by nationals of Israel. This language is permissible under the commerce regulations. It must be reported, but you can agree to it. But if you see the same exact language, go into example 5, the same exact language that's captioned to boycott of Israel would not be permissible. You report the fact you received the language, you can't agree to it, you ask the counterparty to change the, take the caption out, please. And then example, the next example, go down, show out example 6, is again the same thing, but there's a change in there. Instead of just talking about the import and customs laws, it talks about the import, customs, and boycott laws. And again, that reference to the boycott is a poison pill, as it were, making this language also impermissible. So my question, maybe DJ and Jim can address this later. Do you think if you agreed to this language today, it would be okay under US anti-boycott law? I kind of think it's still a problem because the language says you're going to comply with the boycott laws of, well, maybe the boycott laws aren't there anymore, but it looks a little bit problematic. Let me move down now to the last two, and I promise you the last two. And this is just the famous Treasury regulations distinction between it's okay to agree that the UAE law shall apply, but you cannot agree to comply with UAE law, at least before a few months ago, because UAE law contained a boycott statute. Now the boycott statute's gone, and so you can probably make a pretty good argument today that agreeing to comply with UAE law without any qualifying language is probably okay now, but don't take that as legal advice from me. So my takeaway is this: the legal environment has changed. The documents out there haven't. Don't be the last person to get sanctioned for an anti-boycott law violation. That would be most unfortunate. Don't let your guard down. Be careful. Don't let an issue go by unnoticed. There's still impermissible language out there in the market. There are still reporting obligations. And if you fall into any of those categories DJ mentioned earlier, then you are subject to US anti-boycott law.
Yeah.
John, that's about all I really understand on the subject.
Yeah, thanks. That's a great segue to dialing back to DJ. DJ, what are we talking? First of all, if you can address Charles' question and in that context, in the context of the sanctions, what are the penalties now for violations?
Sure, John, and thank you, everybody. Always refers to the, bringing the outside counsel to talk about the parade of horribles could go wrong, right? So first I wanted, because I think we got a question in the chat feature too, but it's a perfect segue to sort of distill what both Jim and Charles kind of touched on, which is, so what are the impacts of the Abraham Accord? What of the last 30 minutes that we've talked about has changed, if anything? So first, US law hasn't changed at all. US regulators have not issued any amendment to the regulation or the underlying statute. Importantly, that includes the Treasury Department publishes a list of boycotting countries. It does that quarterly. It's done that every quarter for the last 20 plus years. Their most recent list that they published post-dated the Abraham Accords and yet continued to include the UAE. The only thing that changed was they dropped an asterisk. And they put an asterisk next to it and said, we are aware of, they didn't use this language, but in effect, the Accords. And we're continuing to determine what that means. So basically, the Treasury Department punted. And so their next list will come in early February. Sort of an open question about whether or not they will amend by then or not. Personally, I think we probably need one more list because I think the effect of the presidential transition may make it difficult to make that kind of policy choice during the January, February timeframe, but we'll see.
But DJ, one to Charles's question, if the U.A.E. is no longer a boycotting country, if that comes out in the Federal Register, do those provisions, those contract provisions that we looked at, numbers 7 and 8, do they, when some of the others as well, are they still problematic?
Yes, that's why I wanted to, I was sort of touching on three things that are sort of how does this impact? So first is the actual regulatory change, and the answer is there hasn't been. There may be in the coming months. Two other pieces, which is second, even if there is a regulatory change, that will not impact the ability to agree to comply with specific boycott-related language. If you're a US company and a Canadian company asks you to comply with the Arab League boycott of Israel, and you agree to that, that's a violation of the boycotting rules, even though Canada is not a boycotting country. So regardless of whether the U.A.E. stays on the list or not, starting in February, if the language in the clause is specifically boycott related, you can't agree to it and you have to report it. So Charles, I agree with your comment about that and boycott language that's in there. And as everybody saw in there, we scrolled through a bunch of clauses real fast, but in effect, the addition of one word in the middle of a paragraph changes it from permissible to impermissible in many cases, and I think it does here. But importantly, that does leave the third bucket of those final two clauses, which I do think you can, Charles said, make a credible argument. I'm obviously not providing legal guidance to everybody on the phone, but from my perspective, I do think you can make the argument that the general statement, you agree to comply with the laws of the U.A.E. That was always permissible under the commerce regulations. Under the Treasury regulations, they say that's an implicit boycott demand because the U.A.E. laws have a boycott provision in them, except now they don't. And so the fact that there is no boycott provision in the U.A.E. law anymore means that a general agreement to comply with those laws, I would argue, is no longer a boycott-related agreement. Treasury has not said that. They have not issued any guidance on that point. I would expect them to eventually. The US government gets around to things quite slowly, and when it's boycott related, it's even slower. But so I would put the sort of effect of the accords in three buckets, which is one, eventually we will get an actual change to the boycotting countries list. Second, even if we do get that change, no matter what, you always have to monitor for things that are affirmative references to the boycott. It doesn't matter from where they are. But despite that change, or even without that change, the general agreement to comply with the laws of the U.A.E. is probably now permissible. If it says the boycott laws of the U.A.E., you probably still have a problem, even though the boycott laws don't exist. So with that, Sharat, let's turn briefly and say, all right, despite all these things we've said, it went wrong. And what's the downside risk? So just put up the one final slide of the sort of the penalty / risk. So the commerce rules, if you violate the commerce rules, this is a very traditional, it's effectively part of the export control regulations. So in the same way as if you were to re-export a product to a place you're not supposed to, there's a civil enforcement process that can lead to warning letters or ultimately penalties. And in theory, there's a criminal referral process if you do it sort of knowingly and willfully. This is not a actively enforced area. You probably get 6 to 8 a year or so that are coming out from the Office of Anti-Boycott Compliance or OAC in the Commerce Department. But you do see them, and you do see some very big names getting fined. There was a couple big banks a few years ago, some big US sort of manufacturers a couple last year. So it does still happen. The Treasury rules are a little different. The Treasury rules aren't a penalty per se. It doesn't say thou shalt not do this. Instead, it says, if you comply with the boycott, or if you agree to comply with the boycott, if you have one of those clauses, you effectively lose your foreign tax benefits with respect to that jurisdiction. And actually, at the beginning, it's the entirety of the jurisdiction. And then you can make arguments about it should be just with respect to the particular operation or contract. The net effect of that can obviously be enormous, depending on your tax structure. If you lose the ability to claim. There's 3 different types of tax benefits that are at issue, but if you lose the ability to claim that on your foreign income, often that can result in double taxation of that same income. The challenge on the Treasury side is because those penalties are part of your tax filings, they're confidential. And so we never have a public statement of, no offense, Jim, I'll say Accenture got a penalty for $10 million it lost $10 million of tax benefits. We'll never hear that. And so you only ever get sort of anecdotes of enforcement, but the Treasury rules are still enforced, and they are a much higher risk from a purely financial perspective for many companies. And as we talked about at the beginning of the call, that's it's particularly ironic because they're also the rules that apply with the broadest jurisdiction. And so for many of the folks on the phone, this may be the issue, which is some part of my group is likely subject to Treasury jurisdiction because they're paying US taxes. And depending on how the group is structured, if they're claiming foreign tax benefits on any of the UAE related earnings, you need to make darn sure the UAE is not complying with the boycott provisions or you're not agreeing to it in any of the clauses, because otherwise the US taxpayer will lose that tax benefit. So back to you, John.
Thank you, DJ. Okay, Jim Stearns. In terms of your clientele at Accenture, what's the message for them now? And of course, for our audience, as being sort of the business advisor, if you will, going forward, we have all this good legal advice and insights. What are the practical takeaways here? And when do you think we will have even more clarity, from say Treasury and Commerce?
Well, if I knew when we would have more clarity, particularly given the uncertain position in Washington, I would probably quit Accenture, use my gambling skills and move to Las Vegas and do very well there. For those of you who work regularly in trade in the United States, you recognize that there is it's a very, very strange time. Well, let me address it. DJ and I have talked about this, and I think that more clarity from where the Treasury Department is going has to wait. Hopefully, it'll be in the February cycle, but may wait another cycle. What we're picking up, and in the Q&A, DJ can, but we're not picking up anything that suggests that the Biden administration is going to change the position of the Abraham Accords. Obviously, it would be very, very difficult to do at this point. But I think, as DJ says, it takes a long time for the government to move. And this is not high up, I suspect, on the list of the Biden administration. And the Treasury Department probably won't move until they get a signal from the Biden administration that it's permissible to do it. Now, I take the position that the Biden administration will come in on January 20th. If we were to debate that one, we'd probably spend the rest of the hour on it. But that's the position that we have at Accenture going forward. We are in a discussion with Francesca Gori, our Middle East people, with DJ, with myself, as to how Accenture should handle the entire question. We have been reviewing U.A.E. contracts to make sure that there are no other non-apply comply with U.A.E. law clauses in there. As I've said, we've only gotten 2 since the Abraham Accord. Our position going forward is probably, and I underline the word probably, not to report the compliance with U.A.E. laws as a boycott request, but we'd feel much more comfortable if the Treasury Department would come out with formal guidance. We think it's a strong legal argument, as DJ's made it, that just saying that we will comply with the laws is permissible. We also emphasize, and that's why we continue to review the contracts, that if it says you will comply with the boycott of Israel, it specifically calls that out, and that's going to be a problem. So we're in flux. The advice I would give overall is to be conservative, to watch very closely what the Treasury Department guidance that they may come out with, and to consult with your outside counsel and your specialists in this area. Because obviously, if you were to make a mistake here and to disclose, the penalties, as DJ says, of losing tax benefits would cause could cause a tremendous financial problem. To say nothing of the screaming you get from your tax people saying, "What are you doing here? How could you get us in this position?" Now, Charles, John, I hope I've been responsive to your question.
And great. Yeah, thank you, Jim. I think, speaking of questions, I think, Liz, we have some questions from the audience.
One sec. That is correct.
Okay.
And I'd like to offer Ms. Bellas to ask her a question. Leslie, would you like me to ask the question, or would you like to ask her?
It was already addressed, actually. I think David addressed it. So thanks. And he read it and then incorporated it. So thanks.
Thank you.
Well, thank you, Leslie, for the question. Great. So, well, I have a question. What do you say to what's the quick answer to the business people who we without doing? And by the way, this was a great deep dive from a legal perspective, and but our business people client, what's I think the quick answer, maybe I'm answering my own question, correct me if I'm wrong. The quick answer is you still need your lawyer. It's probably not going to be as time consuming, but you still need to have these things checked out. I think that's one lesson. Is there anything else we tell them?
Well, this is Jim Stearns. Let me address that, John, if I might. We work, as I said, through our legal team in the Middle East, who helps us talking to our business teams. But I think explaining to your people why that is the case, and understanding that the Abraham Accords did not necessarily, depending on the type of boycott request you would get, eliminate any compliance responsibility is important. I mean, I think at least I'll speak for Accenture, I think it's important that the business people understand that the short headline they get, that the boycott's been repealed, does not necessarily control everything that they're doing in their business. But that is John, that is the word that we give out.
Okay.
And if I could just supplement briefly, thanks, John and Jim. I think what I would say, I agree with you, Jim, and I agree with you, John. You're probably still going to need your lawyers, but there is potentially some silver lining on the horizon, because at least what we've seen is often 80% of the issues are these compliance with laws provisions. Because most companies, what they've done, and it depends on whether you have a structure, whether you escalate all contracts for legal review or to the boycott teams, or you've trained your contract management teams to identify sort of red flag related clauses. And we, often people will have kind of a list of 10 or 12 of the pretty standard clauses, because as Charles pointed out, most of these things have been around for decades. And so you sort of all know more or less it says eligible to enter airports. All right, I got to flag that for somebody. It says something about compliance. I got to flag that. So you've got that kind of list, and people are escalating those. 80% of the things that, at least that I see that are escalated, are compliance with the laws of a country, because it doesn't say anything about a boycott. And from a local contract, if I'm a U.A.E. counterparty, it feels perfectly natural for me to ask my contractual counterparty to agree to comply with the laws of my country. There's nothing wrong about that versus, bringing in geopolitics by specifically referring to a boycott or Israel. And so I think you still do need that process in place, people to identify boycott related clauses. None of that goes away, but perhaps the internal referrals will lessen as we get more comfortable on just this compliance with laws piece.
And I agree with you, DJ. We've spoken about that before.
Yeah, and just again to underscore Charles' point, I've been here a long time in the U.A.E. as Charles has, and we have seen the contract forms sort of languish, and they're cut and they're paste, and the U.A.E. is getting much better at that, but they're still around, as those clauses that Charles showed us attest. So that's something that, my guess is though, if you flag that and you point out to the procurement people and the government, they're very well just change it, just give you a new form. We'll see, but I don't think we'll have the trials and tribulations that we've had in the past in dealing with sort of these residual bad contracts.
And there are still, John, it's true that when you receive language that would be impermissible or that looks questionable, number one, escalate that message. I hope has come across clearly. And then if your legal department or your outside counsel say, no, we can't agree to that, we can agree to this instead, and they give you some alternative language, you got to take that back to the customer and say, look, here's what we can agree to, and hope they'll buy that. And if they don't, you got to take it up within their organization until you find someone who will agree to it, or will agree to some other kind of permissible alternative language. Here in the U.A.E., I don't think the customers are out to get you so much. Sometimes they are, but usually they're not. And so you can usually reach a compromise language that will not get you in trouble here or there. But if you miss the issue, and I think DJ and Jim have made this pretty clear, if you fail to make the reporting obligation is one thing, the substantive obligation is a separate thing. They both are requirements. So the fact you got language that is impermissible, but in the final contract, the language is permissible, you've still got a reporting obligation. That hasn't gone away. So it's you keep all of your anti-boycott stuff in place until we know that the Treasury regulations and the commerce regulations that DJ mentioned earlier, until those are in place and the coast is clear. Because until then, we're in a kind of a gray area, and you can still get in trouble.
Good stuff. Well, anything else from the panel? We have 5 minutes. I'd like to, first of all, thank everybody. I know that the team was researching and discussing these hot, somewhat arcane issues, as DJ mentioned. But I certainly learned a lot, and I'm proud of our Legal Affairs Committee. We deal with all the relevant issues, and this is certainly one of them. So thank you, DJ Wolf from Crowell & Mooring. Much appreciated. Jim Stearns from Accenture, Charles Laubach from A Freedom Angel, Liz and Sharad from AmCham. Thank you so much and the team for an excellent webinar. And thank you to the audience for joining. And the Legal Affairs Committee, I know we have something coming up soon, or we're still working on that, Charles, I guess.
We all have stuff. There's always stuff coming up, John. You know that. But DJ has a question or a point to make at the very end?
Yeah, I saw one more question from the group that I think is a great one to raise for everyone here, because it's one that I don't have to answer, thankfully. So this question was, is there anything the AmChams themselves can be doing to help encourage Treasury to move the needle on this? And Leslie, I don't know if you want to raise it yourself.
No, you raised it beautifully. Just, I'm a regulatory lawyer, not Treasury, but what, if anything, can we do to encourage Treasury to take action to take the UAE off the list in February. Or get clarity, some sort of letter or ruling that, yes, it doesn't, clarity for our members.
That's a good idea, Leslie. And I'm wondering, we have the USPAC, or U.S. Public Affairs Committee as well, right? We have Legal Affairs Committee, USPAC. So, I don't think we have a consultant officially anymore in Washington, but that's, we could deal with that separately, right, in a letter. So.
Yeah, no, I'm just asking because I'm a member of the PAC and happy to help.
Okay, great. Well, thanks for that. Yeah.
And from my end, I would say it certainly, I think it would be it's a smart idea. I'm not sure you'll have a receptive audience, at least for the next 45 days, I believe it is at this point.
Right.
But it might be a great point for soon into the Biden administration. They're going to be focused on a whole bunch of really high level stuff, but trying to get their arms around it. But this is a blocking and tackling point to go in and say, like, this really matters to US companies operating in Abu Dhabi and the UAE more generally. And so can you just get this issued? And actually, I don't think it's just Treasury. I was just looking through the commerce regs. When, for example, Israel and Jordan signed the peace treaty, Commerce updated their regs with a supplement within a set of interpretations there. So I think you'd get, I think the push would be, Commerce, can you issue a supplement on what this means for the UAE under your regs? And then Treasury, can you take them off the list and issue some sort of guidance about this compliance with laws point?
Thank you.
Wonderful stuff. Yeah.
Yeah, with further countries lining up to, like we've got UAE, then Bahrain, and who knows who's next, but it could be a few of the people that are on this webinar, a few of the countries where they're sitting. And so if the US government can show it's doing its end, it's going to help the peace process along, I think. So it's a good political, it should resonate well in Washington, that's what I'm saying.
Indeed. Well, thank you again, everybody. Liz, it's 5 o'clock.
Yeah.
So look forward to the next one. And thank you again. We'll stay tuned.
Thank
Thanks,
you.
everyone. Stay safe, stay healthy. This concludes the
Yes,
program.
yes.
Stop.
Thanks, Liz.